Just a moment. There is, I'm going to forward to you, Shilling. There is one, you can just send them the link. There is also a request for a link. Okay.
All right, sure.
Okay, I've just emailed to you.
All right. So I admit this group first and then I'll send her the link.
Yes. Okay. All right. All right. Okay, 37. So total so far. Good afternoon, everyone. I hope you can hear me clearly.
Yes, very loud and clear. Thank you.
Right. Thank you. So we just wait for 3 to 4 minutes before we begin our session. Another 3 minutes, we will begin. Because there are participants who are joining. Okay, a very good afternoon to everyone. We have 67 participants so far. So in a minute, we can start, but let me go through with you the introduction, a brief introduction about this session. This session is going to be 1 hour, and I will speak for about 45 minutes. And the last 15 minutes, it will be question and answers session. This is an interesting topic The topic is, although the topic is more relevant for employers or managers, but it is also important for employees and people in general to know about the laws that relates to termination and dismissal in Malaysia. Okay, all right. So it's 12 p.m. Let me start with good afternoon to everybody, and I would like to thank each and every one of you who have registered for this webinar on termination without violating the law. And another important thing I want to make it clear to everyone is that this session, in this session, I am not going to teach you about uh, termination to become a terminator. Okay, it's not about being a terminator to become a terminator. As far as possible, at the end of this session, we will hope that you can avoid termination. And termination should be seen as a last resort. Okay, all right. Now, my name is Bala Krishnan. You can just call me Bala. And I'm from the Wawasan Open University in Penang. Okay, now let me begin with the outcome of this session. There are 4. At the end of this session, it is expected that you should be able to demonstrate good employment relations at your workplace. It's not only about termination. Termination, as I said, is a last resort. But always remember good employment relation, good employment practices. Second, at the end of this session, you should be able to differentiate what do we mean by termination and what is dismissal. Okay, there are difference between termination and dismissal. Number 3, you should be able to identify and use various types of termination of employment contract. There are many types of termination, and dismissal is just one of the type of termination. Okay, and finally, you should be able to know how do you terminate with minimum risk, because all types of termination, there are risks involved. Now, what are the risks? The risk that the employee or the workman might take you to the industrial relations department and the case might go to the industrial court. Not only industrial court, from industrial court, it might even go to the high court, court of appeal, or even to the federal court. So remember the outcome of the session. Okay, at the end of the session, as I said, the last 15 minutes, feel free to interact with me with your questions. Either you use the audio or you can type in the chat box. Now, let me start by giving you some of the the news that appears. Okay, the news that appeared in our Free Malaysia Today, Malay Mail, The Age. I have just selected 3. There are many. If you do a search under unfair dismissal claims, unfair dismissal awards in Malaysia, you can find a lot of information. In fact, if you go and do a search in the Industrial Court Awards, in fact, if you do a search in the Industrial Court Awards, you can find a lot of dismissal awards. And let me tell you, this awards mostly does not favor the employer. It mostly favors the employee. Like in this case, you find there are awards that even goes up to 2 million. Like awards that goes from, it ranges. How do we calculate how the industrial court determines the quantum of the awards? We can discuss about this. Okay, maybe not in this session. There are various formulas. But let me tell you that if you look at the statistics from the Industrial Relations Department, okay, these are the latest statistics. I don't have the latest statistics from the Industrial Relations Department or from the Industrial Court. The one that I have searched, the most recent I have searched, this is the one that is available. I do not have the statistics up to 2022. But even if you are looking at the statistics up to 2020, 2019, 2018 and 2019, you can look at the amount of compensation that has been paid by the employers to employees for unfair dismissal cases, unfair dismissal or unfair termination cases. And among the highest in terms of unfair dismissal or unfair termination, it's a case of misconduct in employment. And you can find the recently from year 2020, okay, after COVID time, retrenchment is also increasing. I can tell you that the last few years, the numbers of cases in the retrenchments are also high compared to misconduct. Now, what do we mean by misconduct? I will go through it in our session later. But please note the amount. The amount actually year by year, it is increasing. Okay, I can tell you that the last 2 years itself, it might be about 500 million compensation paid by employers to employees due to unfair dismissal cases. So that is why it's important for every one of you here to remember people management is not something that is easy. It is not easy. You can deal with people. Yeah, you can communicate with people, but when it comes to the matters related to industrial relations, employment relation, at times, what is logic to you, what is right to you might not be right to the other party, that is the employer. Okay, what is right to you? Because people see things in a different way. Those of you who are familiar in the field like psychology will know that each and every one of us are different. We are different in terms of our perception, values, attitude, perception, personality, motivation, a lot of differences. So therefore, when you deal with people or HR, you need to know that you are dealing with the creatures of emotion, not logic. Okay, so very, very important to deal with employment issues or problematic employees or disciplinary issues in a proper way. Now, it's also important. Now, first stage you need to know is that before we look at termination or dismissal, it's important for people in HR or employers to know, to make sure they have employed the right people for the right job. After all, when you are looking at human resource planning, it is all about getting the right number of right people for the right job, at the right time, at the right motivation, right pay. Of course, you are not going to get all those rights. But if you are able to get the right people for the right job, at the right motivation, right attitude, but of course, attitude do change from time. So you need to make sure that you know the right approach in dealing with different categories of employees. Of course, in any organizations, you have staff performers, good. But even staff performers, what are you going to do with the staff performers? You cannot load the staff performers with more and more work. If you keep loading the staff performers with more and more work, what will happen is that they might even get burnout, stress. They might even leave the organization. At the same time, you must also look at what are you going to do with the deadwoods. Every organization, we do have deadwoods. So if you look into these categories, staff performers are those who are highly competent, highly motivated. So when I say competency in management in HR, it simply means those who have the the sufficient skills, knowledge, attitudes in order to perform the job. They are competent, highly competent people. But the people who are competent, you need to get them to move higher. What we are going, that is not a focus of our session, but I want to tell you that you can't punish the star performers. At the same time, you must also watch those categories who are competent, but the poor in terms of attitude and motivation. What are you going to do? And you must also investigate why they are there, why they are able to do, but they are not willing to do. There are many reasons. I can provide you many reasons. There are reasons from various research studies. There are reasons that you can see from your experience. So the category will not do, can do, even if you do training, it's not going to work. So you have to look into other HR intervention in order to manage these categories. And of course, you have the category that will do but cannot do. Yes, this group, yes, competency development like training will be able to help. But what about those who will not do, cannot do? If let's say they fall under the category of poor performer, how do you make sure you remove the poor performers? And you can't just simply terminate the poor performer, because if you terminate the poor performer, if the employee who have been terminated takes it to the industrial relations department and the case is being heard in the industrial court, the burden of proof will be on the employer to prove the employee is guilty, not the employee proves himself innocent. So it's important for you to analyze various categories of people. Okay, in what category the problematic employee is. Actually, the problematic employee at times can even be in a star, but their area, if you look into performance, if they are able to perform in some organization, even though they are problematic, but if they are able to perform, they will not be what do you call given any forms of corrections or even punishments. So now let's look into termination. Looking at termination, remember, very difficult task for any managers, any employers. And from the studies, from my analysis, I can tell you it is always due to poor selection. Poor selection. Okay, in the beginning, if you're not able to select the right people for the right job, right time, right place, you get into performance-related problems. Not only performance-related problems, other problems. And as a result, you might have to terminate. And it is also due to ineffective people management. Like for examples is that you don't give a clear performance goals to the employee. Performance goals are not there. Sometimes the performance goals are not there when the company or organization have no clear direction, no vision, no mission, no proper structure, no performance goals given. They do not know what is expected from them. So in one of the industrial court case related to termination of a poor performer, it is said that before you want to terminate the poor performer, make sure you have given the employee, the employee clear performance direction, performance goals, competency development need to be there. And even there are other processes like PIP, performance improvement plan, and others before you terminate cases like poor performers. Now, if termination is unavoidable, proper planning is necessary. That's why you have to plan. Before you do anything, before you start anything, always look at the how to finish. Begin with the end in mind. Stephen Covey, some of you are familiar with Stephen Covey. Begin with the end in mind. So, termination. Now, when I say termination, can be categorized under two, voluntary and involuntary. Now, voluntary termination usually initiated by employees due to resignation, due to retirement. Since year 2012, we have minimum retirement age, 2012, 60. But if the contract of service provides retirement age higher, then that will be applicable, but it cannot be lower than 60. Resignation, an employer needs to explore, need to research. Why do employee want to resign? Why do they want to go? And when you go into the literature, not only literature, you know from your own experience. Many of you are working in organization will know from your own experience that people leave due to two factors. One is a factor. Now, the factor that is mostly research is that the push factor within. Push factor within a company, the culture, the management attitude, the discrimination within the company, the workload, the wages, the security of employment, working environment, working relationship, so many factors within that might push them out. The other factor, of course, you know, pull factor. Pull factor is the attraction from other organizations or other locations. That pull factor usually constitute roughly about 20 to 30%, but the push factor is considered to be around 70 to 80% why people leave. That's voluntary termination. But you also have involuntary termination. Involuntary termination, we're going to look at in depth. How do we deal with some of this involuntary termination? So as I said to you, involuntary termination, if I show you the one that I've shown to you earlier, is by the employer, not initiated by the employee, by the employer. And it is often due to misconduct. It can be due to absenteeism. Absenteeism, if you look into our law, in the Employment Act, you have section 15, subsection 2, talks about absenteeism. Okay, then you have poor performance. And then not only misconduct, poor performance, and due to indirect dismissal, that is called constructive dismissal. I will talk a little bit about constructive dismissal later. How do we avoid constructive dismissal? Dealing with constructive dismissal and also avoiding constructive dismissal. Now, types of termination. I mentioned earlier about termination. Retirement and resignation is not much of an issue. Everybody will be able to handle it. Every employer, HR people will be able to handle retirement and resignation. Before 2012, there are many issues related to retirement when the contract of service never mentioned anything about retirement. I'm not going to go into those cases, but just to tell you that you might not face much problem, number one and number two. Number two, at times, you might have fewer cases, but number three, look at number three is a breach of contract. What is breach of contract? Breach of contract means either party in the employment relationship, either whether it is employer or employee, can breach the contract. So when you say breach of a contract, how a contract can be breached? Like in the Employment Act. See, remember, Employment Act recently has been amended. You have the amendment in the year 2022. Okay, of course, there are a lot of things I can talk to you about the amendment of the Employment Act, but this session is not about Employment Act and the amendments, but people who are in the HR will be familiar with what are those amendments. Okay, I can tell you few, okay, like you have maternity leave that is increased from 60 to 98, you have paternity leave, you have arrangement for flexible working arrangement, discrimination of employment. Another important thing, Employment Act now covers all the employees except certain areas, certain sections. Okay, those days, before the amendments, Employment Act only specific to certain group of employees. Now, similar to Employment Act, you have to remember, covers only Peninsular Malaysia and Labuan, which is a federal territory. Now, what about Sarawak and Sabah? If there are participants here who are from Sarawak and Sabah, you are covered by Sarawak Labour Ordinance if you are in Sarawak, and Sabah Labour Ordinance if you are in Sabah. And please note that there is no amendments yet for Sabah Labour Ordinance and Sarawak Labour Ordinance, but it is hope that it will be coming soon, but we do not know when. All right. Now, breach of contract, like if you take Employment Act, Section 15, subsection 2, what it says, an employee is deemed to be absent from, an employee is deemed to have broken his contract of service if he's absent absent for more than 2 consecutive working days without informing or attempting to inform his employer. So if the employee is absent more than 2 consecutive working days without informing or attempting to inform his employer, there is a breach. Now, what happens if there is a breach? It's possible for termination, but you have to remember there are many such termination under Section 15.2 whereby the employer, just by reading the Section 15.2 and terminated the employee, the termination, when it goes to the industrial court, it was said that the termination is unfair termination. Unfair termination means termination without just cause or excuse. Now, what you have to do? There are many things you have to read carefully the clause, the section, without informing or attempting to inform the employer. So it is better to give a letter to show cause why disciplinary action should not be taken against you, against the employee. Show cause letter maybe about 5 working days or 5 to 7 working days. If the explanation is not acceptable, then yes, you can proceed with the termination. I can cite you many such industrial court cases because I have been following the industrial court cases for many years. Almost every time I read through to understand why such case judgment differ from one. Sometimes a judgment or the award given by the industrial court chair might even be different from one another, even in a similar case. So you have to see the reason for the decision and many other things. So breach of contract, number one. Breach of contract can even be by the employer. If the employer does not pay the wages by the 7th day of the month, that is also a breach of contract by the employer. So in that case, what will happen? Okay, what the employee can do? First, the employee must communicate with the employer. If there is no response, then they can refer to the nearest labor department, Jabatan Tenaga Kerja, JTK. If there is a non-payment of wages, can even lead to constructive dismissal. Constructive dismissal is another type of dismissal. I will go through it later. So breach of contract, of course, not absenteeism and non-payment of wages. I have mentioned there are many other types of breach of contract. That means the essential terms and conditions of the contract not fulfilled by either party can also be a breach or repudiation of a contract. So, someone need to mute. All right, thank you. All right, there is a breach of contract. And remember that the contract of employment also cannot be changed unilaterally by one party. It has to be based on the agreement of both parties. Now, number 4 is frustration of contract. A contract of employment can also be frustrated. People who are familiar with law will know what is frustration of contract. The frustration of contract happens when either party in the employment relationship unable to fulfill the need of the contract. For example, if your employee has been detained under police detention, can he come to work? So what happens is to his contract of service. Let's say you employ a driver's license has been suspended. Can he drive for your company? But of course, he can't drive for your company, but so his contract can be frustrated. But as a caring employer, you might offer him other tasks, not as a driver. So let's say your employee is sick, prolonged illness. The sickness is continuous. No, he's not able to recover. As a result, he or she is not able to fulfill the need of the contract. So frustration of contract can apply, but make sure you get a medical report from a registered medical practitioner before you terminate. Even frustration of contract for employer, if the government orders the factory or the company to close down due to environmental hazards, that is also the frustration of contract. So there are many cases on frustration of contract. And then number 5, fixed term contract, ending of a fixed term contract. Usually a fixed term contract expires upon completion of its term. If it is 1 year, 2 year. But let's say if the employer continues to use a fixed term contract, renew several times, and then they decide not to renew, it can be unfair. There are industrial court cases that I can use to support the award given by the industrial court in Hanchang High Schools versus Teachers Union back in the year 1988, 1986 or 88, if I'm able to recall. And then the most recent Azizi versus Jambatan Kedua in Penang. And there are many cases whereby the company employs someone on a fixed term contract and they renew the contract. They keep renewing maybe 4 or 5 times, and then they decide not to renew the contract because they want to replace the fixed term contract, the one with the fixed term contract with someone else, and the job has yet to become redundant. Job is still there, and they did not renew. That will be unfair, and that employee can take the case to the Industrial Relations Department, and it can even go to industrial court. Many such cases has taken place. Number 6, non-confirmation of a probationer. You have to remember, as per the industrial court, high court and federal court, a probationer, in fact, if you do a search in the Employment Act, Industrial Relations Act, you will not find the term probationer there. Therefore, the probationer falls within a scope of employee within the Employment Act and workmen within the scope of Industrial Relations Act. Okay, I'm not going to go into the definition of who are employees, workmen. Nowadays, employee, workmen can be considered, since the amendment of the Employment Act, an employee is also a workman. But Industrial Relations Act, Industrial Relations Act, and also Trade Unions Act 1959, they don't use the term employee, they use workman. These are some legal definitions that are different, but I will not go into that. So, probationer, confirm or not to confirm, need to be based on a fair labor practice. Most of the time, employer do not do proper assessment, and at the end of the probational period, when they see that the probationer not performing, not doing well, they will tell the probationer that we are not confirming you. And we are not confirming means it's a termination. And that termination, if the probationer takes to the Industrial Relations Department or industrial court, the burden of proof will be on the employer. So make sure you have a proper assessment of a probationer from the beginning. Let's say if it is a 6 months probational period, the first month itself, first day, giving him or her clear performance goals, maybe assign a mentor, someone to assist, and then provide the right training. Always assess the first month, assess the performance. Check if there are anything not up to the mark. And then if it is not performing, then you can start with a verbal warning, and then you have to make sure you record the verbal warning. And then after the third month, okay, maybe the second or third month, performance still not up to the mark, even though you have given him or her the right training, exposure, everything have given, still not up to the mark. Okay, first written warning, and you have to outline what are the areas to improve. Okay, and then after the third or fourth month is still not up to the mark, maybe the final warning. Okay, final warning, if the performance not up to the mark, the company will have no choice but to not to confirm. Not to confirm means termination. Then let's say the probationer who has not been confirmed takes it to the Industrial Relations Department. You have evidence to show that you have done your level best to assist, but there is no improvement. If you do not have the documentation or the evidence to prove, it will be deemed as unfair dismissal under Section 20 of the Industrial Relations Act. Then you have retrenchment. Okay, so far you all able to follow. Okay, I need to pause for a while. Anyone can respond? Can you follow? Everyone able to follow?
Yes, sir, can follow.
All right,
Yes.
all right.
Yes,
Thank you.
yes. Thank you.
Thank you. All right. Now we go into number 7. Number 7 is about retrenchment. Now, why do we retrench? How do we retrench? See, retrenchment. Okay, now before I talk to you about retrenchment, you need to remember under our Industrial Relations Act, Section 13, subsection 3, there are 6 rights given to the employers. That is called managerial prerogative or managerial rights. One of the right to hire. Number 2, right to assign work. Number 3, right to promote a workman from a lower to higher category. Number 4, you have right to transfer. Now, transfer, you have to be very careful because there are times when you transfer, the transfer is seen like a demotion, can be a constructive dismissal. And I can show you many such transfers. Transfers can become a constructive dismissal. Cases like Wong Chi Hong versus KT organization, cases like Batma Subramaniam versus Dickens Hart, many cases in the past, even present, unfair transfer can lead to transfer that is considered to be detriment to the position of an employee can be unfair dismissal, can be considered as a constructive dismissal, not unfair dismissal, constructive dismissal. So it's very important for you to be clear with when you transfer and how do you transfer. So transfer can be that. Okay, beside transfer, I mentioned section 13.3 of the Industrial Relations Act also provide the right for the employer to terminate due to redundancy or reorganization. Redundancy and reorganization. And then it also says the number 5. Okay, number 5. Sorry, not number 5, number 6. The right to terminate and also right to dismiss and reinstate a workman. Not only dismissal, but also to reinstate the workman. These are provided in section 13.3 of our Industrial Relations Act. So remember, termination due to retrenchment is there within our law, but the employer must first prove there is redundancy. Now, what do we mean redundancy? Redundancy means that the job or the task or the work is no longer required by the company. That is called redundancy. If there is no redundancy, there will not be a case for retrenchment. Retrenchment is reduction. You might call right sizing, downsizing. Okay, retrenchment. So retrenchment, although it is not there in our law, but industrial court over the years suggests, this is suggestion, using formulas like LIFO, last in, first out, last person in that particular position that has become redundant will be the first to leave. All right. But let's say if the employer do not want to use LIFO, last in, first out formula. They want to use other formulas. Yes, but they must have reasonable reason. So a lot actually retrenchment now. For retrenchment, there are some requirements like you need to submit PK form. People in HR will know what is PK form to the nearest Jabatan Tenaga Kerja, JTK. And then there are many actually other things. Now, before you retrench, what are the things you need to do? You know you have surplus labor. When you have surplus labor, you don't retrench immediately. You have to do many other things. Reduction in terms of manpower, like freeze hiring, encouraging people to go for early retirement. Maybe you can offer, the company can offer MSS, mutual separation scheme, for some employees, or voluntary separation scheme. Now, what is the difference between MSS and VSS? Mutual separation scheme is based on what you call negotiation or agreement arrangement that you make with certain group of employees, certain type of employees that you select. Voluntary means you open to everybody. Everybody wants to take the package. Now, actually, if you look into retrenchment benefit now, as per our law, it is very low. As per employment termination and layoff, 1980, we are still using that, 1980. There is no amendment yet. For those who work less than 2 years, it is 10 days wages for every year of service. 2 to 5 years, it is 15 days wages for every year of service. And then if it is more than 5 years, it is just 20 days wages for every year of service. But when the company offers VSS, it will be higher. The last choice, of course, you go through retrenchment. When you have to retrench, then the formula will be applied. Formula is applicable. The formula is applicable for those within the scope of the act, the Employment Act. Okay, now retrenchment. Now, besides retrenchment, we are now going to 8 and 9. 8 and 9. Okay, I have another 10 to 15 minutes to speak about 8 and 9. Then I will be happy to answer your question. I think even if it goes longer than 1 hour, I'm fine with it. Okay, we can continue to interact. Okay, number 8 is dismissal. I mentioned to you in the beginning, one of the outcome is to differentiate between what is termination and what is dismissal. Dismissal is a type of termination. If you put in a box contains various types of termination. Dismissal is just one type of termination. So if you look into number 1 to number 9, all termination, but dismissal is just one type of termination. But the outcome is the same. Employee leaves the organization. Now, dismissal can be due to two. One is called misconduct. Misconduct is there in our Employment Act, Section 14, subsection 1. It is defined. I read for you what is Section 14, subsection 1. I don't have to read. I remember the Act well. Section 14.1 says the employer on grounds of misconduct of the employee inconsistent with the express or implied terms and conditions of his service may dismiss, downgrade, or impose any lesser punishment after due inquiry. So this means misconduct. When you want to terminate, you have to make sure proper process needs to take place. Okay, a misconduct has been committed. You can't simply terminate someone because the person have committed misconduct, even though you have evidence. Even though you have CCTV evidence, you have all the evidence, still you cannot terminate without giving the right to be heard, because rules of natural justice need to be adhered in a termination or dismissal. For example, a misconduct has been committed. You can start with a show cause, letter to show cause. If the answer is not acceptable, you can proceed with the domestic inquiry. Before that, there are many other processes. Domestic inquiry, before that, the investigation, many things you need to do. But DI, you have to come out with a charge sheet. And sometimes, let me tell you this, very important. At times, an employer can lose a case in the industrial court due to poorly written charge sheet. Charge sheet is surat tuduhan. The way you write the charge sheet is very, very important. You need to make sure that the date is there, the time, date, time, place, what was the misconduct. All this needs to be clear. If the charge sheet is white, case can be lost. Because one of the principles of natural justice, a person need to know clearly what he or she is accused of. So misconduct, charge sheet. In fact, a domestic inquiry begins with a charge sheet. A domestic inquiry begins with a charge sheet. So when you say domestic inquiry, why? Domestic inquiry is required by statute, Section 14, subsection 1 of the Employment Act 1955. And you also have similar section in the Sarawak Labour Ordinance, Sabah Labour Ordinance. And section, like for example, Section 14.1 of the Employment Act says, like what I have read to you, given to you earlier, the need for domestic inquiry. Section 14.2 says the employer may suspend an employee up to 2 weeks for the purpose of inquiry with half pay. Okay, I'm not going to go into that. In case if you attend my training on managing misconduct, domestic inquiries, laws on dismissal, termination, it will be covered in that, especially like charge sheet. How do we go about in charge sheet? Many cases in industrial court, high court, even federal court, in a case where charge sheet not properly written, the employer can lose a case. Okay, misconduct, you need to do a domestic inquiry. Now, what is a domestic? Domestic inquiry need to be done based on the principles of natural justice. There are two principles of natural justice to all participants. You need to know natural justice. Number one, audi ultram partem. Second, nemo, judax, in causasa. I'm talking to you, speaking to you in Latin words. Latin, some of the law legally they use a Latin word. Audi ultram partem means hear from the other side. Before you pass a judgment, before you condemn. No one is condemned unheard. Hear from the other side. Lord Dennings clearly, Lord Dennings in many of his judgment, you see, people within the field of law will know Lord Dennings. Hear from the other side. The accused should know clearly the case against him. He must be given the right to answer, not only to actually see, hear, and answer the allegation made against him. So natural justice, first fulfillment, law of natural justice in domestic inquiry, you hold a domestic inquiry, right to be heard to the other party. Second, nemo judex in causasa, no man shall judge for his own cause. People who have any interest in the case should not be there in a board of inquiry. So when I used to do programs like domestic inquiry, board of inquiries, you have to make sure they are impartial. Board of inquiries, you usually have 3. The chair, 2 panel members, maybe one more, you can have a secretary. Then you have the prosecution, you have the accused, you can call in witnesses. That will be very long if I'm going to talk to you about domestic inquiry, what are some of the common mistakes, how to do a domestic inquiry, which is not part of this session. So you have misconduct. Only after domestic inquiry, found guilty, yes, you can. You have the right to terminate. You have the right to dismiss. Even that dismissal, the employee can take it to the Industrial Relations Department or to the industrial courts. The other one is poor performance. Now, firstly, you need to clearly define what is performance. You can't simply say the person is performing poor performance when you have not clearly given him or her a clear performance goals. And the performance goals need to be aligned with the company's vision, mission, goals, strategies, action plans, based on the overall company's direction, vision, mission, goals, and strategies. It can be cascaded to what we call departmental goals. Most companies, they don't have a clear vision direction. That is why they are unable to provide a clear performance direction to the people. So when the performance, performance management, performance appraisal in HR different. Most of the time we see people give just a praise, but don't give a clear performance goals. People do not know what is expected from them. Many companies, they don't give a clear performance goals because they don't have a clear direction. So when the performance, make sure performance goals are clearly communicated to every employees. Performance goals are clearly communicated to every employees. Now, sorry, I need to go back there because I wanted to admit one participant just now. Let me go to the previous slide. Okay, previous slide. Okay, right. Performance goals needs to be clearly provided to every employees. And then you need to, now part of performance management programs, goal setting, competency development, performance monitoring, then you appraise based on the goals that you have set. Usually in an appraisal, 70 to 80% must be outcome based. But most of the time what happens, it can be due to behavior, it can be due to trait. They look into the behavior, the employees' behavior at workplace, whether the relationship, okay, relationship with the superior, relationship with the peers, okay, and then their trait, but not on the outcome. What is to be measured is the outcome. 70 to 80% of the performance management should focus on the outcome. Also the appraisal, not on the behavior and past. Okay, behavior and the trait. Behavior and the trait can be just 20 to 30%. Now, I can cite you many. In fact, I have gone through maybe over hundreds of different awards related to poor performance, managing poor performance. I can just summarize in few areas. If you want to make sure, if you want to terminate someone on accounts of poor performance, you need to make sure first that person who is performing poorly must be given a clear performance instruction, performance goals. Second, you must make sure he or she has been given a clear competency development, training, assistance. Number 3, If let's say the performance is still not up to the mark, he must be warned. Warning must be clearly communicated. What are the performance shortfall? What he needs to do, what he or she needs to do in order to improve. Okay, that is number 3. Now, not only verbal, but you must also make sure you are giving not only verbal warning, but written warning. And when you start with the written warning, you have a process that is called PIP. Some of you from HR will know what is PIP. PIP stands for Performance Improvement Plans. So in the performance improvement plans, you need to clearly communicate what should be done. What are the areas to improve? If you have done, let's say after PIP, performance still not up to the mark, not able to meet the requirements, yes, you can terminate, you can dismiss for poor performance. And even if the employee takes it to the industrial relations department or to the industrial court, you have ample evidence or documentation to show. Usually, the employer loses the case when they don't have a proper documentation to show in the industrial relations department or industrial court. Okay, that is for poor performance. And the last type of termination, okay, this is something this happens now. I can go through constructive dismissal is very detailed. Anyone interested, you can go and search under my name, constructive dismissal. There was an article that I have written, published about constructive dismissal. That was about 7-8 years ago, but the article is still relevant. You can find. I search under my name, full name. You know my name, Balakrishnan Muniappan. You can search constructive dismissal. You should be able to download the article from the research page. So you have constructive dismissal. Okay, I just want to pause for a while. Are you able to follow? Okay, everyone able to follow? All right, thank you. Now, what is constructive dismissal? Constructive dismissal happens when, let's say, the employer doesn't like the workman. I use the workman because I'm following from the Industrial Relations Act. Workman or employee. Employer doesn't like the workman, but the employer knows that if he dismisses, terminates the employee can go to IR department, file under section 20 for unfair dismissal. So what the employer will do? The employer will make the employee life difficult in the company. Every day, humiliate the employee. Every day, let's say, give him unattainable target. Okay, every day say, oh, you need to go. Please leave. Go. Not please leave. That's the door, you can go. Many things he can do. Okay, you might file and then harass the employee. Harassment here can even be sexual harassment also can fall within the scope of this constructive dismissal. I can cite you many cases of sexual harassment that the employee wants constructive dismissal. Of course, the landmark case is that Lilian Pereira de Costa versus Janico Sprian Berhat. But of course, she won in the industrial court, but she lost in the high court and then again lost in the appeal court. But there are many cases. Flora Ganaprahasam versus Sitat Sendran Berhat. That case in the year 2002. Case went up to high court. And she actually won the case. Constructive dismissal sexual harassment can also be constructive dismissal. So, like in the words of late Dr. Gopal Sriram, the former, I'm sure you know people in the legal, Gopal Sriram, he said, the employer doesn't like a workman. He wants to ease the workman out of the employment, but he's not able to do so. So he will make the life unbearable to the workman as to drive the workman out of employment. So because of the treatment, because of the harassment, because of like the unilateral changes in the job scope, these can be constructive dismissal. But the constructive dismissal, you have to remember the burden of proof falls on the employee or the workman to prove the employer is guilty. Now, in my paper, I define constructive dismissal. What is constructive dismissal? Is a fundamental breach of employment contract that goes to the root of the contract. Court usually uses a contract test. There is also another test, reasonableness test. Contract test is applied when dealing with constructive dismissal. So there are many cases. I have a list of cases. If you more detail about constructive dismissal, please read the paper I have written long ago. You can search the paper in a research gate under constructive dismissal under my name instead. Okay, all right. Constructive dismissal. Now coming to almost like 10 minutes. Since I said I'm going to give you time for you to interact with me. Now remember termination in a normal termination, unfair dismissal. Burden of proof is on the employer to prove employee is guilty. So you have to remember that in a dismissal case, employer must provide sufficient evidence that the workman committed the offense. So it's very important to remember that the basic principle of industrial jurisprudence in Malaysia is that the employer must prove the workman guilty, not the workman who proves himself innocent. So if a person is innocent unless he's proven guilty. Person is innocent unless he's proven guilty. So this is considered to be the basic principles of industrial jurisprudence, that no employer should go to the industrial court in ignorance of this principle. You have to remember that. Burden of proof. Unfair dismissal, the burden of proof is on the employer. Unfair dismissal. Let's say constructive dismissal. I mentioned to you earlier about constructive dismissal. Constructive dismissal, employee must prove the employer is guilty. Burden of proof is on the employee. Usually, let me tell you, constructive dismissal is about 50-50. But I have seen many, even the constructive dismissal, yes, the employer able to win the case against the employer. Because employer or the workman able to provide sufficient evidence to prove that the employer have breached the contract that goes to the root of the contract of employment. So know the distinction here between unfair dismissal, constructive dismissal. Okay, you remember earlier all the types of dismissal I have gone through. Now, even constructive dismissal falls within the purview of Section 20 of the Industrial Relations Act. Constructive dismissal, a landmark case in Malaysia, as I mentioned, is of Wong Chi Hong versus Cathay Organization back in the year 90s. Wong Chi Hong won in the industrial court. When the case was heard in the High Court, he lost. At that time, late Tun Harun Hashim was a judge of the High Court. Company won, Cathay Organization won. He appealed. The case was heard in the Supreme Court. At that time, it was called Supreme Court. Now we call Federal Court. At that time, Supreme Court, the Lord President, late Tun Saleh Abbas. Some of you might know who late Tun Saleh Abbas. He gave the award for constructive dismissal against the company. Constructive dismissal therefore comes within the purview of Section 20 of our Industrial Relations Act. So what is Section 20? Section 20, okay. People in HR, you know, but people, everyone who are not in HR must remember that company cannot terminate or dismiss you without just cause or excuse. If the company terminates you with just cause, without just cause or excuse, this is open to everyone. Anyone, any workman or employee, as I say, can file unfair dismissal claim within 60 days. Dalam tempoh 60 hari, 60 days, they can file at the Industrial Relations Department. Okay, and then of course it won't go down. There will be a conciliation meeting. After conciliation, it can go to industrial court. Those days reference will be made to the minister, and then it goes. But now it can go direct to the industrial court, and then the case will be heard in the industrial court, and the industrial court will make what we call awards. Okay, all right. Okay, important. Okay, I'm coming to the end of the talk. Coming towards the end of the talk. Remember, a clever person solves a problem. Wise persons avoids the problem. I don't want you to solve a problem relating to termination, dismissal. Usually I give advice. I have been an advisor. I've been an advisor for employers. Some employers do consult, because over the years I've been in this field. I know many of I will tell can or not, what they can do, what they cannot do. And I have also advised employees, some of them, but I don't go into depth. If it's depth, then I will go through consultancy. That will become consultancy. I just give the general perspective. I don't go into the detail. I have even given advice to lawyers who are not that familiar in the industrial relations related area. And my paper, whatever that I have written, have even been cited in the industrial courts by the chair of the industrial court in making the awards. So I can tell you based on my experience, okay, you don't have to solve, you don't go into solving, but the most important thing you have to remember, avoid. Avoiding, I mentioned to you many things that you can know. Always look into preventive measures. Start with your selection, start with your competency development, training, performance management, employment relation. I can go on and on about preventive. Do not be reactive. Be proactive in preventing termination from the beginning. Okay. Actually, I should be, how do we avoid? That can be one area that I can talk to you. How do we avoid? How do we prevent? It's a long area. So I want to tell you in conclusion, I see almost 1 hour. I thought I wanted to give you 45 minutes, but it has gone beyond 45 minutes to 1 hour. In a conclusion, I just want to tell you that you don't rely on law. Law is your last resort. The last. Law is not a substitute for good human resource management practices, HR practices. So remember, it's not a substitute for good HR practices. So with that, I conclude this session. If anybody wants a slide, maybe let me see, I can, what do we call, share in the chat. So I have completed. So the last maybe 10-15 minutes, I will look into Q&A. Let me see from the Q&A. If I want people to, what do we call, use the audio rather than the chat box, because chat box, I see there are a lot in the chat box. Okay, let me see from the chat box. Anyone want to ask direct? Okay, let me check. Okay, let me check.
Hi, sir. Maybe I can go first. I actually
Yes,
typed in
sure.
the chat box. How long should we conduct a PIP before we actually terminate an employee?
Okay,
So
how
like, what's
long
a
to
good
conduct? Okay,
period?
how long to conduct a PIP? All right. Now, PIP, there is no specific time range that is given as per the law. Actually, not given anything on that. But in general, it might range from 3 to 6 months, depending on the position. It's just like you are asking a question: how long the probationary period will be? Probationary period dependent on the job, depending on the position. It can be, let's say, 1 month. It can be 3 months. It can be 6 months. It can be 1 year. In some cases, it can even be up to 2 years. There is nothing in the law that prevents. Let's say you want to do PIP within 3 months. Yes, possible. You can do it within 3 months. But you have to make sure when you do a PIP, clear performance goals that needs to be achieved during the time that they need to demonstrate. At the end of PIP, what they should be able to demonstrate, what they should be able to show, achieve, needs to be very clear. And there must also be clear support on the employee to achieve the PIP. You don't just leave the employee there by himself or herself to go to the PIP. Okay, any more question? I prefer people talk to me directly rather than, I don't want to go through reading it because there are long here, a lot. I see a lot. I'll try to read some.
Dr. Bala.
Yes.
Feng Ming here. Yeah.
Yes. Yes, madam.
I just want to seek your opinion, for this case. Now, this employer actually had done 2 size down redundancy twice, and each time the company actually the package that they pay out, they follow the norms that means the practice in the market, which is for every year of service 1 month salary. All right. So now this is a norm, but however, unfortunately, this round, the third round that the company is doing at another time, but they decided to fall back on the law. So that means to say that, as what you say, less than 2 years is 10 days, 15 days, 20 days kind of thing. So now this is the third time, and the third batch of employees felt actually they feel that it's very unfair. So they actually wanted to seek legal advice. So what do you think that has the company done the kind of like precedence? Have they said it in that sense?
Okay, if the company have in the past, sorry, can you hear me? All right, company have try not to provide anything lower than what they have provided in the past, because it will be seen as unfair. The employee can take legal action. If they have the proof of not a legal before that, before they will go through the company's grievance procedure. If there is something that is called grievance procedure within the company, they will have to write within the grievance to know why they are being poor. If the company do not have a clear justification, now there can be a clear justification like due to financial situation of the company, due to economic downturn, due to reduction in customer. There can be financial or other justification for the company, but you have to make sure you give a clear justification. If the justification is not clear, yes, the employee can go to the either the industrial relations. They might accept or not to accept. If they don't want to accept, if you terminate and you provide under what they call the retrenchment, they might even take it to the industrial relations department. So although I do not know in depth, because I have to study in depth what it is based on your general perspective, my advice is that try not to provide anything lower than what you have provided in earlier group of employees, so that it will not be seen as a discrimination for this particular group of employees.
Okay, right. Thank you.
Okay, anybody through audio?
Prof.
Yes.
Prof.
Yes.
Professor Bala here, same name.
Yes, Prof.
How are
Okay.
you?
Good.
I'm about to flying, go to airport another 5 minutes. Okay, never mind.
Okay.
I'm
All right.
listening. Prof, I have a question to you. I think you also remember some cases that you remember. I share with you some cases that before the COVID-19. Remember, we're using the online teaching, but we already done everything according to this one. Only thing that we are not able on class lah. We're online, but the teaching process taking place. Am I right? But this one reflect to me, actually some of the friends' case lah. But what happened is the dean sent the letter, take action to, very funny, take action. We're going to take action on this particular person. They said you're not attended the class face to face, but the class already run. The student prefer because we're using YouTube, everything. But the letter came to they sent to the law department, legal department, and legal was laughing, at the moment this case. So what is your advice to do on these particular cases? I think we are pity because they say after that COVID came in, when COVID come in, everybody, the whole using online. So what base you're going to take action? You cannot, even now, I think we are working on that. So this kind of employer, do you think they have knowledge or no knowledge? And why they do like that?
Okay,
and
thank you.
Okay, thanks, Prof.
Thank you, Prof. Okay, I think you discussed about this earlier. I think yes.
Yes.
I'm just to note for everyone: public institution, private institution, the regulations are different. Okay, when you're taking about Employment Act, for example, Employment Act is applicable mostly in the private institution. Public, they have a separate laws, rules. But let me give you an overview, the picture. In this particular case, I can go in depth about what we do. But first thing is that the leader or the heads or whoever who are involved need to be trained or educated in terms of the legal aspect of employment. Okay, legal aspect not only in terms of the laws related to what they call termination, show cause letter, but also about performance management. Okay, I just want to say this. Of course, we can go into depth, but I think it is not necessary at this moment. The only thing is that they need to be communicated. They need to be trained. They need to know what they can do, what they cannot do within the perspective of the law. All right. Thank you, Prof. Anybody else who wants to?
Hi,
Anybody else who have written?
Professor
Yes.
Susian
Yes.
here.
Yep.
Yes, can I ask a question here? It's actually also based on the chats. So even if the staff memo, which the staff have been briefed and agreed that he understands, state that certain misconduct warrants immediate termination, can the employer proceed with termination or must proceed with domestic inquiry?
Okay. Now, these questions will also open another area of discussion. Can you terminate without domestic inquiry? Now, let me tell you, there are few cases in industrial court. I have mentioned that it is not fatal if you have not done a domestic inquiry. But let me tell you, if you do that, that is a very high risk on the part of employer, because Section 14, subsection 1 of the Employment Act clearly mentions the employer on grounds of misconduct of the employee inconsistent with the express or implied terms and conditions of employment, after due inquiry may dismiss, downgrade, or impose any lesser punishment. So due inquiry or domestic inquiry is considered to be a must before you terminate. Even though you have ample evidence, if you terminate without domestic inquiry, the risk of losing a case for unfair termination or unfair dismissal under Section 20 is very, very high. Okay, I hope that's clear to you.
Yes, understood. Thank you.
Dr. Bala,
Yes.
can you hear me? Yeah.
Yes,
Surya here.
Suraya. Yeah.
I just want to clarify my understanding. Yeah, we were in the pandemic before, we were in the MCO. I mean, I just want to relate to Prof. Bala just now, the question, right? Where at that point of time, everybody understood that they are allowed to actually work from home because there is no other way, correct? But right now, with everybody coming back after the pandemic, and there is already a clear instruction in certain organization and certain institution for a staff who has been informed to be back to work. If they fail to do so, it is insubordination, right? I just want to clarify.
Yes.
Okay.
Insubordination, yes. Okay, that is insubordination is a type of misconduct. You can consider as a major misconduct. Misconduct, there are many types, many categories of misconduct. In fact, if you go into industrial court, always they cite one particular book on misconduct that is called BRIA, Misconduct in Employment. Many categories. Misconduct can be related to duty, misconduct can be related to morality, misconduct can be related to discipline. So insubordination means not following lawful order of a superior. That is insubordination. Now, again, you have to look into what are lawful order. Lawful order must be law order that is within the scope of this employment contract. That is the terms and conditions of employment. Anything that is not within the scope of his contract of service will not be considered as a lawful order for that particular employee. But again, when we look into insubordination, now we have to also look into now in dealing with misconduct. We have to be very clear. The company must not condone any past misconduct. If that past misconduct, if the company, let's say there is a doctrine of condonation in employment law. If you keep condoning any misconduct and all of a sudden you want to take an action, that will also be considered as a unfair. So you have these are some of the things you need to be aware. Okay, anyone, just speak to me directly because I'm not going to read through the chat. Speak to me directly what you have written.
Okay, thank you, Dr. Bala.
Okay. Okay, there is a question. There is direct message sent to me. Some of you send direct message. Okay. Can an employer force an employee to sign resignation letter? Okay, forced resignation can be constructive dismissal. You cannot force. Okay, that's the answer for you. Gui Han Yang, me. Okay, our student, DBA student. The answer is no. Okay, another question, also direct message. How many times maximum can fixed term contract? maximum of there is nothing given in the law or even in industrial court. But let me tell you, fixed term contract, if you keep renew so many times, that will be seen like a permanent employment. Okay, let me check. Somebody asked, got certificate for this training or not? This one I'm not sure. This is human resource. This training is a training week of HRDC. So I'm not so sure about the certificate. Okay, let me check if there are any. Okay, another question also comes direct to me. I remember if not confirmed, normally there will be, okay. If not confirmed under probation, even the probation period when you go through, it's almost like a PIP. Okay, probation period is different. Now, PIP is for the confirmed staff. Okay, PIP is for the confirmed staff whose performance is not up to the mark. Okay, somebody, all right. All right, let me check. Okay, another question here. Even if staff manual, okay, all right, I think this question has been answered. Okay, now any special circumstances, additional legal consideration come into play, termination of employee with disability or during pregnancy. During pregnancy, you cannot terminate. This is clearly mentioned in the Employment Act. Cannot terminate a staff except cases of major misconduct cases, any misconduct cases. Okay, you can refer to the also is there in a recent amendment of the Employment Act. Disability, okay, disability, frustration of contract will apply. Remember the type of employment termination I mentioned, number 4, frustration of contract. Okay. Another one from Veronica regarding poor selection. Okay, any tips? Okay, how do we select? Okay, that's another area. In the past, I used to do selection tools, many types of selection tools. Most of the time, you rely on interview directly, but there are many types of selection tools now available. Okay, but of course, even with that, you can still. I can tell you, even failure of an HR to clearly, okay, identify or even verify or check certain things like documents, like qualification, can become unfair dismissal too. Let me tell you one case. If you want to go and check this case, you can check this case. Nordin Mohammed versus MISC. This case was heard in the year 2005. He said that he has a qualification of ICMA. And then when 9 years ago, when he joined the company, but when in year 2000, when the company want to digitalize everything, he cannot produce his qualification. And the company terminated. And he filed a termination for unfair dismissal in industrial court. But actually, in that particular case, company won. There are one thing actually saved the company. But if you are interested, you can go and search that particular case. Nordin bin Mohammed versus MISC, Industrial Court Award in the year 2005. So it's very important before you select, you go through everything. You must make sure. Selection, do not rely just on interview. Interview, anybody can say anything during an interview. Many things they can tell you. Okay, another direct message come to me. Backstabbing an employee by colleague, bad mouth, superior to the superior. This actually there is no question. He didn't ask question, just a statement here. Okay. How long we should conduct PIP? This is answered. Yes, there is another direct question. Many cases go to industrial court, high court. Must hire a lawyer? Yes. Industrial court, if the employee want to represent himself, he can. Okay, the high court, yes. Other courts, yes, you have to hire a lawyer. Okay, and then direct message. Many low-level employees may be unaware they are unfair dismissal. Okay, this is where education is necessary. Nowadays, many employees are aware. In those days, they might not be aware, but now many are aware. They know, they are familiar. They get to know. They ask people around. They ask around. They know. There is a section called Section 20. Section 20 protects against unfair dismissal. Right for employment is considered for right for right to livelihood. This is also confirmed by in our federal constitution. Right for livelihood, and also right for employment. Security of any of employment is protected. Okay, Dr. Nagaya, okay, thank you. If employment, not project. Not project based, it's better to go on a permanent. Okay, this is for Shaharia. Okay.
Sorry, sir. Okay,
Yes.
I'm Shahira. Okay, you're looking at my questions just now. Okay, so for these situations, if we hire staff by continuous fixed term contract, and maybe the employer is renewing like over the years with the employee, but maybe at some point, maybe employer feels that having an issue with the employee, but they are giving a termination by end of the contract to the employee. Is it possible for the employee to to have a report? This one is as part of the constructive dismissal. Thank you.
Okay. If the fixed term contract, during the fixed term, usually fixed term contract expires, there is no termination, expiry. But let's say if you want to terminate, possible is if there are misconduct, if there are poor performance, if there are breach of contract, yes, it is possible. Other than that, no. You have to make sure it expires. But if let's say during the fixed term contract, performance is poor, based on whatever I have mentioned to you about dealing with poor performer, and let's say if it is a misconduct with the show cause, with the DI and everything, yes, you can, possible. But the fixed term contract, if you, as I said to you, higher and higher and higher. Now, remember, if the person has retired, then I have not seen a case which involves retirement. Below retirement age, if you keep hiring, it seems like a permanent employment. It is like a permanent employment. So yeah, this is based on several industrial court awards that you need to be aware of.
Thank you,
Okay.
sir.
Monica Chan, are there any circumstances additional? Okay, now this one we have looked at earlier. Stephen, okay, if there is a problem, probationer. Now, probationer, you want to terminate the probationer, you have to look into your contract of service. Let's say after the probationary period, performance not up to the mark. If the contract of service mentioned there is extension, company may decide to extend or not to extend. If the contract of service never mentioned there is an extension, you need to make sure that you make a decision there. And you have to remember, probationer is the same as a permanent when it goes to an industrial court. There is a case, Talia Abbas versus Pesaka Capital, long ago. This case, industrial court, that case went to Court of Appeal, if I'm not mistaken, confirms that the probationer have a right like a permanent employment. The only thing he has not been confirmed in a position. Okay, now from Toby, employment is a okay. Now, this is coverage of the Employment Act. Coverage of the Employment Act now for all employees with a contract of service. However, only those with 4,000 and below will be eligible for certain provisions, certain sections in the Employment Act, such as the overtime payment, like you asked about the overtime payment. Yes, for them, yes, it is applicable. Okay, and there are other sections also that are applicable for those with 4,000 and below. 4,000 and below, plus those who are doing manual work, those who supervise manual work, also falls within the scope of the Employment Act. Okay, Murshid Hafizi. Okay, I would like to ask, let's say I have a staff member who is still in probation, performance not meeting expectation, can we as an employer terminate after probationary period and rehire for a new? Okay, now you want to terminate him and you want to rehire for a lower per salary. Is it the same person? Can you clarify? Okay.
Yes, Samson.
Okay, see, when you want to now, when you want, you don't have to terminate here. Okay. When you want to, in this particular case, okay, let me tell you, make sure you have given all the, you have done all the things I have mentioned in dealing with poor performers, for professional whose performance not up to the mark. Warning, training, okay, guidance and everything. Now, after the performance is not up to the mark, okay, you may want to consider, okay, you may want to consider transfer, or it can be even a, now, usually when I say like a demotion, it can be demotion, it cannot be a demotion. Well, if you have to communicate, I think in this case, you have to communicate directly with the employee. If he or she wants to accept, if he or she wants to accept, okay, then you proceed with what you want to do. Otherwise, you cannot. You don't. Okay. Okay. Now, Poonam Devi, I think our student DBA. Yes, background checking. There are many types of background checking that you can do. Some of the things you have to do it legally. Some of the things you can search. Nowadays, you search in a social media, you can know many things about individual. Okay, Sharon, direct message. Employee under probation suddenly become pregnant. Can be under no. Okay, this one you have to, the employee, before the employment, you have to get confirmation from the employee. But there is nothing wrong. If the probation, let's say the probation period is 1 year, the employee gets pregnant, that's is nothing that the company cannot terminate during that period of pregnancy. From Ellen, our DBA student, do you need to provide solid evidence why extension is need also PIP during extension period? PIP is for confirm employee. Okay, after PIP, company can decide. If the let's say after PIP for a permanent employee, company can decide either to terminate, they can terminate. If the company decide not to terminate, redesignation, demotion, also they can do that. But make sure you have the evidence of non-performance or poor performance during the PIP. Okay. This is a direct message. What's the maximum duration for employee to remain confirmed poor performance? Maximum, there is nothing maximum. But let me tell you, company cannot keep the employee in a poor performance state for a very long period of time. Because if they do, it is considered to be what we call, you are condoning the poor performance. Okay, another direct message. Do you need to provide solid evidence for extension? Okay, I think this I have answered this. All
Mr.
right,
Bala, got one question. Let's say
yes.
if you're extending a contract, is there can we extend it continuously, or do they need to be a cooling off period?
Can have a cooling off period, but let me tell you that cooling off period is a shorter period of time for the renewal for the next one. That's fine.
So is there any period which is acceptable or by law?
Law is silent, nothing mentioned in the law, but this is based on practice.
Dr. Bala, if
Yes,
there's the
Chung?
if there's a transfer clause mentioned and the employee refuse, can that be terminated?
Transferability, okay. Under section 13 subsection 3 of the Industrial Relations Act, one of the employer's prerogative is the right to transfer. But the transfer should not be detriment to the position of employee. If the transfer is like a promotion, if they're to a new place, a transfer is where the terms and conditions are better, maybe yes. But if the transfer seems like a demotion, there are many cases I can cite for you related to transfer. If you read through the article, if you want, I can send you the article that I have written. The transfer which is seen like a demotion will be unfair labor practice, and the employee can resign and claim unfair dismissal, unfair termination, under unfair constructive dismissal under section 20.
Same category.
So
same category.
Same category that will not have any loss of anything to the employee, fine.
So can that be terminated if you refuse?
That you have to look into case by case. I have to see what is the case. Okay, if the transfer is fair, is there any major changes in the terms and conditions of employment? All that things needs to be investigated, needs to be assessed before I can conclude whether can be terminated or not to be terminated, what can be done.
Same condition, everything same.
Everything same. Okay. Now, Everything is same. Is there a different location?
Yes,
If there
different
is a different
location.
location, is a company providing additional support in terms of accommodation, in terms of allowances for the employee to get settled in a new place? All these factors have to also we have to see. Okay, we also
Yep,
have
thank
to
you.
see because
Yep, thank you.
sometimes like a case like I mentioned, Badma Subramaniam versus Declan, the employee was working in Subang Jaya and the company was going through retrenchment reorganization. Just to avoid paying her retrenchment benefit, they transfer her to become to Kota Kinabalu in Sabah, so that she will resign. She will not take, but she did not resign. She claimed constructive dismissal and she won the case. So you have to consider, you have to see many factors before making a decision, okay, in terms of this transfer, because unfair transfer can lead to constructive dismissal. All right, I think there are many questions coming. I need to stop this in a moment. Anybody last question? You can just use the audio before I conclude.
Yeah, I have a question, Bala. Loga here.
Yes, Dr. Loga.
There have been cases where I know you were talking about termination without violating the law, but there have been cases where candidates who are coming for the interview they belong to the LGBTIQPA+, and they have been turned down. What's your view on this?
Okay, this falls under discrimination of employment. Now, discrimination of employment, see, you need to remember that in the Employment Act, there is discrimination of employment, but the discrimination of employment doesn't apply to pre-employment. It is applicable during employment. If there are any form of discrimination employee feels where they are treated differently with other employees, some employees receive these, they get these privileges, they're not giving these privileges, there has been discriminated, many things they have been discriminated, they can use that.
That's right.
Because the discrimination of employment is applicable in Employment Act, but not pre-employment. Okay, during the employment. But of course, first thing they have to do is that they have to, let's say if the company has a grievance procedure. Yeah, okay. For those who are not familiar, grievance procedure is not like a complaint. It's like a, if let's say employee is dissatisfied about anything in the organization. Okay, first thing, let's say HR here, any HR leaders here, let's say if your company do not have a grievance procedure, you need to make sure there is a grievance procedure. Okay, now back to Dr. Loga's question. Dr. Loga's question. Pre-employment, this is not applicable. Pre-employment, if the employee feels they have been denied, rejected, they can take a case against the employee separately, but it is not within the scope of the what we call Industrial Relations Act, in our Industrial Relations Act.
Thank you.
Dr. Bala.
All right.
Can application form or during the interview ask the person whether the person is pregnant?
In the application form, okay, there is nothing that prevents, but you don't usually they can what they call ask a question. Mostly they will ask this question during an interview rather than putting it in the application form. But
So
as far as a law, that is nothing that will prevent also, because it's not been seen in that particular case before employment. That is nothing related to discrimination in employment, pre-employment. If in India employment, anything you cannot discriminate an employee who is pregnant, especially when it comes to termination, except cases like misconduct.
Okay, thank you.
All right, everyone. Okay, that's the end of our session. Actually, it took us 1.5 hours. I would like to thank the organizer, WOU Academy, National Training Week, HRDF. Okay, just a moment. Let me check if I can, what we call, share this slide. Just give me a minute or two. Let me check if for those of you, okay. Okay. It says here the PPTX cannot be sent because, okay, wait, let me close this first. Just a moment. Give me a minute. Let me close this and try to send again. Okay. Okay, I've just sent the PPT. If you are interested, this is a slide that I use, maybe for your reference. For your reference, you can, if you are able to download, you can download it. Hope this session is beneficial to all of you. And thank you again to everybody who have attended this session. All right, thank you to everyone. I will pass
Thank
it to
you.
the organizer, WOU Academy. Shiling, you want to close? You can close.
Yes, yeah, thank you, Dr. Bala. Thank you everyone for attending the workshop. So we will share the slide. I mean, like we will send an email together with the slide to them as well later. So yeah, you may leave now and enjoy your lunch if you haven't. Thank you very much.
Thank
Thank
you.
you, sir.
Thank you.
Thank you. Bye. Thank you.
You.